The transcripts are out. I'm Karen Friedman Agnifilo from Legal AF, and we just got the transcripts from the arraignment in federal court of Donald Trump in the Southern District of Florida. We heard lots of reporting from reporters who were in the room. Don't forget, there were no cameras allowed. There was no recording allowed. So we did get lots of reporting from people who were in the room. But we finally got the transcripts. I got to read them myself. And so let's talk about exactly what happened in Donald Trump's federal arraignment in the Southern District of Florida. So he was arraigned by Judge Jonathan Goodman. Jack Smith was also there. We are told by reporters he wasn't sitting in the well, so he wasn't mentioned in the transcript anywhere, but we know he was there. The arraignment started at 2:55 p.m. and it ended at 3:44 p.m. and it was in courtroom 13-3. This was both the initial appearance and the arraignment of both Donald Trump and Waltine, also known as Walt Nada. An initial appearance is the first time you go to court. The arraignment is when you are told what your charges are. They most of the time happen at the same time, but not always. So this was both the initial appearance and the arraignment of Donald Trump. It was only the initial appearance of Walt Nada. His arraignment has been put over a couple of weeks, and I'll tell you why in a minute. The lawyers who were there, the prosecutors, were Jay Bratt, David Harbach, and Julie Edelstein. And the lawyers for Donald Trump were Chris Keiss and Todd Blanche, and Stanley Woodward appeared for Walt Nada. Pretrial Services was also there, and Pretrial Services is a really important agency that works for the federal government, and they interview every single person who's arrested, and they make a recommendation to the court about whether the person should be released, and if they or should they be held. You know, in other words, should they be held in jail pre-trial, or should bail be set, or are there conditions on their release? And Pretrial Services will also monitor somebody who's released with conditions. So that's what Pretrial Services is. I don't know whether or not they interviewed Donald Trump. I assume they did, because that's part of the standard arrest processing. And so we'll get to that in a minute when we explain what the conditions are that the judge set. So the judge started by thanking everyone under the sun, including literally the entire law enforcement community, the court reporters, everybody, just thanked everybody. And then he reminded everybody that there's no photos or videos of anyone in the room. You're not allowed to use devices. And that includes people in the spillover room. So what that told me is they had a spillover room. There was a room, which is very common to do if the courtroom's not big enough to hold all the people that there is, when there's cases that have a lot of interest, they open up another room and they stream on video what's happening in the courtroom. And so the judge was speaking to both rooms, both the people in the courtroom as well as the spillover room, that there's no photos, no videos, no recording whatsoever. So the judge took the defendants, both Trump and Nada, separately, and they didn't. In other words, he didn't do both at the same time. He just did Donald Trump first, and he asked Donald Trump's lawyers, are they temporarily representing him or are they permanent? And that's important because sometimes attorneys appear for arraignment only, and then a defendant goes and looks for a more permanent lawyer. You can also change lawyers at any time, but these lawyers, Todd Blanche and Chris Keiss, indicated to the judge that they were permanently representing Donald Trump. And so they might add new lawyers to the team. There was lots of reporting that they're interviewing other lawyers, but apparently these two lawyers are in for both the trial and the appeal. They said that on the record as well. The judge then said, normally in this district, people waive the formal reading of the indictment because it's 44 pages long. If a defendant doesn't waive the formal reading of the indictment, they would have sat there and the judge would have, or the clerk would have read every single thing that's in that 44-page indictment. However, Donald Trump's lawyers said, as is very common, we waive the formal reading. of the indictment and entered a plea of not guilty, which is also was expected. That's obviously he's going to enter a plea of not guilty. And he demanded a jury trial. And that's a formality that you have to do. You demand a jury trial. And so that's noted on the record, and he'll get a jury trial. The judge then went on to explain what's typical in our district, is how he put it. So he said, and so it sounded like he was educating both the lawyers who don't necessarily practice there every day and Donald Trump, as well as everybody else who's reading these transcripts, knowing that we would read them. He wanted to make sure that he was educating everybody. So he would say things like, what typically happens in our district, the typical steps in our district are that the defense would request a standing discovery order. Is that what you're requesting, Mr. Blanche? And Mr. Blanche would say, yes, Your Honor. So a standing discovery order means that there's an order by the judge. Standing means it's in effect the whole time, the whole pendency of the case. And an order means it's a court order, because only the court can order you to do anything in a criminal case. And it's a discovery order, which means the government is under an obligation to provide discovery at the appropriate time to the defense. Then the judge says, and I assume you want a Brady order. And he said, I assume that the prosecutors know their Brady obligation, but I'm doing a standard Brady order as well. And Brady comes from a very famous case, Brady versus Maryland, which is a Supreme Court case that's been around for decades. And it basically says if a prosecutor has any information in their possession that is exculpatory to the defense, they must turn it over. And they must turn it over right away. You can't hold on to it. You have to turn it over at the soonest possible practicable time. And you have to say, I have this information in my possession that tends to exculpate you. It means it tends to show your innocence. Even if you think the person's lying as a prosecutor, it's not up to you to say, well, I think that person's lying. I have a witness who came forward and said it wasn't him. That's considered Brady. You have to turn it over. So the judge issued a standard Brady order. Again, standard. So then they get to the part, and this is the part that I found, frankly, somewhat disgraceful, because they get to the part about bail or bond, right? About release, because, everyone was calling this arraignment perfunctory, and I heard a lot of people say it's just perfunctory. It's just an arraignment. Well, now I've been a prosecutor for a very long time, and now I'm a defense attorney. There's nothing at all perfunctory about bail. About an arraignment. You are formally told what your charges are. And I tell all my clients, and frankly, most as a prosecutor, you assume the same. I tell my clients, bring your toothbrush. You don't know that you can't, there is no way you can assume that you are not going to have bail set in a case, or you could be remanded, which means, no amount of money will get you out. It means it means you are held and detained, period, full stop, no bail. But oftentimes, if you do set bail, there are large amounts of money, especially in really serious cases. So I'm probably the only person who didn't think this, but I didn't think it was going to be no conditions to Donald Trump in a case like this. But apparently that's what happened. So the judge asked the prosecutor, Mr. Harbach, I'm seeing that you are not recommending any dollar amount for bail here. And the prosecutor said, that is correct, Your Honor. And you are recommending a personal recognizance release, which just means you get to walk out. That's it, on your own. That's correct, Your Honor. And that is recommended by the United States, right? Right. And you don't want any conditions imposed other than because there's two standard conditions, number 1 and number 5, which basically are like, come back to court and don't get arrested. That's it. Just don't commit any other crimes while you're out. But the other conditions that are standard conditions that everyone else has to abide by, they don't apply, right? You don't view him as a flight risk, do you, government? Government says no. So you're not asking for any special conditions? Nope. No financial component? Nope. And he says, 18 USC 3142 sub A sub 1 allows a defendant to be released on their own recognizance on an unsecured bond if they're not a flight risk and the person won't endanger the safety of another person or the community. And he said, basically, are you asking that he not surrender his passport? Are you requesting that? That's standard. I've never had a client who hasn't had to surrender their passport in federal court. That's outrageous. Okay. No limitation on international travel. What about domestic travel? Is there any limitation on that? Because, it's standard. A standard condition is no travel outside the Southern District of Florida or whatever district you're in a federal case. Again, all my clients can't leave the district that the case is in. That's a standard condition of release. Nope, Your Honor, we don't see that as necessary. Okay, then they get to one that says, how about the standard condition of forbidding him from possessing firearms, government? What's your position on firearms, ammunition, and dangerous devices? Nope, no problem. He can do that too. And then the judge says, what about, are you requesting that he avoid contact with the co-defendants? And you know what they said? Nope, we're not requesting that either, Judge. Walt Nauta works for Trump. So that would not be practicable. So nope, he can have contact with the co-defendants. And the judge then said, are you requesting that Donald Trump report to pretrial services in any way? Again, every one of my clients has to go to pretrial services. And they said, no, they said, we're not asking for that at all. They're not asking for any special condition of release. And pretrial services said the same thing. They said, we're not requesting anything either, Judge. And so the judge says, well, okay. And clearly this judge was surprised because this is so highly unusual and Donald Trump is being treated differently than everybody else once again. The judge said, you know what? Despite of course, the defense has no objection to that, right? Why, as a defense attorney, would you have any objection to these incredible terms and these incredible conditions? Because Donald Trump, this doesn't matter. He can just go about living his life, despite the fact that he has another open indictment. And we know of 2 more open criminal cases, pending investigations, both January 6th with Jack Smith and Fulton County with Fani Willis. But despite the fact that there's 2 indictments now and 2 other pending cases, no conditions, Judge. And I bet if you looked in the entire country, you will not find another case involving a defendant who has 2 separate indictments in 2 separate jurisdictions and 2 other pending 2 other pending criminal investigations, and they get this kind of a deal. But he's Donald Trump, and so here he gets this. But I think the judge was a little taken aback that there was 0 conditions, and he is going to protect the integrity of the case because, he's the judge. That's all he really cares about is the integrity of the case. So he says, however, despite the party's recommendations to me, I am going to take it upon myself to impose some additional special conditions. Thank you, Judge. Thank you for, being the grown-up in the room and seeing that, guess what? Donald Trump is a criminal defendant and shouldn't be treated differently than everybody else. And he says, I'm going to require that Donald Trump avoid all contact with witnesses and victims except through counsel. And this will be effective once the defense attorney receives a written list of those witnesses and victims from the prosecutor, the prosecution. This prohibition is only effective to those people who are written on the list. And he's also said the second condition is he can't communicate with his co-defendant, Walt Nauta, about the case except through counsel. So in other words, he can have contact with Mr. Nauta since he still works for Donald Trump, but they can't talk about the case unless they're with their lawyers. Now, Todd Blanche, Trump's attorney, objected to these conditions. He says this isn't practical. The witnesses include his protection detail and everyone who's around him every day. It's just like with Nauta. This happened at his home in Mar-a-Lago. It also happened at his other home, Bedminster. These people work with him every day. And he says, then he says, and one witness is the president's lawyer. Obviously, that doesn't work. That was surprising that I'm sure he means Evan Corcoran. And so Evan Corcoran is still his lawyer. And even though we know he's the one who is turned over his notes and is telling everybody telling the prosecutor what exactly what happened and what Donald Trump did and said. So that was interesting that Trump still considers Evan Corcoran his lawyer. And then the prosecutor says, okay, you know what? Let me make a suggestion. Mr. Harbach says, let me make a suggestion. The government will come up with a list, not all the witnesses, but a list of people who this requirement is necessary for. And that will accommodate Mr. Blanche's issue about incidental contact, because Mr. Trump, speaks to these people every day. So and Mr. Blanche, Todd Blanche said, you know what, I'm not sure about this. I don't want this. I don't want this requirement. But Harbach says, the prosecutor says, you know what, Judge, let me and Mr. Blanche try and come up with something, a proposal for you, Judge, and we'll come to you with a list, and I think we can sort this out amongst ourselves. Clearly, they were caught flat-footed and didn't realize this was going to happen, and they were totally unprepared, because they spent the next, I'd say, 10, 15 minutes going back and forth about this. Should we have two lists, one for no contact at all and others for don't discuss the case? And Blanche is upset about this and says, we can't do this. And, and then Harbach says, well, give us time to try to work it out. And they're going back and forth and back and forth. And at one point, Blanche says, why should there be any conditions? Everybody, all the witnesses have lawyers, and then the court says, that's a really broad statement. In fact, every single witness has their own lawyer. But then, of course, he hems and haws and walks that back, because he doesn't want to admit that, yes, everyone has a lawyer. How do I know? Because Trump is paying for everyone's lawyers. But that's neither here nor there. That's what I think. He didn't mean to spill that can of beans. And so, they go back and forth on this for quite some time. And they ultimately land on because I think Todd Blanche realizes at a certain point, going, wait a minute, because he says, is the court's requirement that the government is going to give us a full witness list? Because we'll take that. And so I think they realized, oh my God, you don't normally get a full witness list. In fact, some people are secret. You have no idea that they're cooperating, and you don't want to let the defense know that they're cooperating, because we know Donald Trump will then, bully them, put their name out there, and really intimidate them, and like he has for every other person out there, call them names, whatever. So Todd Blanche wakes up and realizes this could be a gift, but the judge says, no, not so much. Let's just do this. Okay. Let's just get a list of people from the government that will tell us that who it is that Trump should not speak about the facts of the case. That's it. And if the person's not on the list and he talks about the facts of the case, then he's not in violation of this order. Just people on the list. So the government's going to have to go back and say, they're going to probably say, this is not a full witness list. These are just the people that we don't want Donald Trump to talk about the case with. So we'll see what they come up with. But that was a little bit of a inelegant back and forth that people did not expect. And there was a lot of time spent on that. But then they turned to the co-defendant, Walt Nauta. Stanley Woodward appeared for him, but he's not admitted in the Southern District of Florida, which is a requirement to appear in court there. So the judge used his discretion and allowed Mr. Woodward to represent him and appear on the record for his initial appearance, but not for the arraignment. And so the initial appearance, he gave the same conditions on Mr. Nauta that he did to Mr. Trump, which is nothing. And so it's the exact same bond. And they put over his arraignment for June 27th at 9:45 a.m. before the Chief Magistrate, Edwin Torres. But then he said, there's a federal criminal procedure 10B that indicates Mr. Nauta doesn't have to appear physically if he doesn't want to for arraignment, if he follows the procedures of the rule. But the lawyer does have to appear, which I found very interesting, because that is very different from New York State Court, where a defendant has to appear for his arraignment. But I guess federally you don't have to. So he may or may not appear. He may appear on video, he may appear in person, or he might not appear at all. His bond is already set as exactly what Trump had. And then the judge ends it with, the good news is when Mr. Nauta appears, it will not be with me. It'll be the Chief Magistrate Judge, Ed Torres. My involvement in this case, I think, ends right about now. So he clearly didn't want to have anything to do with this. He just, it was his day that he was signed up to be the duty judge to handle any arraignments that came in, and that was that. So now, after Mr. Nada is arraigned, the entire matter will go before Judge Eileen Cannon, who has been assigned this case through the wheel, which means it was a random assignment, that comes up on the wheel. When they got Eileen Cannon, Jack Smith basically was the opposite of winning the lotto. It was the worst possible hand you can draw, as she's already made some terrible rulings on this case in the past during the investigation and showed that she has bias against Trump. So we'll see where that goes. She has bias for Trump, not against Trump. She has bias against the government for bringing this case. So it was not a great draw. I think this, arraignment was fairly outrageous because, I want to just draw your attention to a couple of other cases. Do you remember Airman Jack Teixeira, who was arrested a while back in Massachusetts? He was a young kid with the Air National Guardsmen. He's the one who posted classified documents about the war in Ukraine on social media. And he also sought to obstruct investigators. He also had a history of violent and racist remarks. And he is also a target for hostile foreign power. This is a guy who worked on IT for classified computer systems. And you know what? He also possessed the documents and only showed them to a small group of people to brag, right? Just to kind of show off, look what I can get, look what I can do. Doesn't this sound familiar? The entire set of facts, getting these documents and bragging to a small group of people and showing it to them, then obstructing investigators, when they try to retrieve this back, and also having a history of violent and racist remarks. Well, guess where Jack Teixeira is? He is in jail. Why? Because he's dangerous and he's a flight risk. And this is a serious case. And so he's in jail awaiting his trial. Also compare it to Chelsea Manning, Edward Snowden, other cases of leaked documents. And, it's just a very familiar that anyone else who does this is considered a threat to national security. But someone who foments a violent insurrection, who spews racist, hateful, violent remarks, and who recklessly and willfully possesses and maintains and shows off classified documents that are our most secret materials, and who also has several criminal cases that are either pending or under investigation, somehow he is released with no conditions because he is once again treated differently than everybody else, but not in the way he means. He gets away with everything that nobody else does because he thinks he is above the law. And it is time now to hold him accountable. Thank you for joining. I'm Karen Friedman Agnifilo from Legal AF. You can catch me on Wednesdays with Michael Popak at 8 p.m. Eastern live on YouTube or wherever you get your podcasts. And you can also watch Legal AF on Saturdays with Ben Meiselas and Michael Popak, also Saturdays at 8 p.m. Eastern.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.